All right, so let's say you find yourself staring at a stack of legal papers about what happens after a judge makes a final ruling. You need to get up to speed quickly on this whole post-judgment world. Well, you've come to the right place because today we're diving deep into Rule 38, Rule 47, and something called collateral attacks, which sound pretty intense.
It's like a legal escape room, you know?
Oh, I like that.
Yeah, you've got to find those hidden clues and the right tools to break free from a judgment that might feel like it's locked you in.
That's a great way to put it. It's not just about dry legal procedures. We're talking about second chances, righting potential wrongs, and figuring out if there's any wiggle room left at all. So to kick things off, what's the deal with this petition for relief from judgment under Rule 38?
Okay, so imagine this. The judge, in your case, has made their decision, it's all final, and you're thinking, wait a minute, something is really off here. Rule 38 is your chance to go back to that same court and say, hey, you need to take another look at this. But here's the catch. It's not just for any disagreement. You can't just say, I don't like the outcome. You've got to prove exceptional circumstances.
Okay, so no buyer's remorse allowed.
Exactly. You need some serious ammunition.
Got it. So you can't just waltz in there because you had a change of heart. You need a strong legal basis.
Right. Think of it like this. You need to demonstrate what we call fame to even get your foot in the door.
Fame. Okay, now you've got my attention.
Don't worry, we're not talking about celebrity lawsuits here. FAME is an acronym to remember the grounds for relief. Fraud, accident, mistake, or excusable negligence. And let me tell you, each one is a tough hurdle to clear.
Okay, I'm ready to unpack this FAME acronym. Let's start with fraud. What would that actually look like in a real-life legal case?
Picture this. Your opponent in the case, they were hiding a crucial piece of evidence that could completely change the outcome. Or, even more dramatic, their lawyer was secretly working against them the whole time.
Wow, that's like something out of a legal thriller.
It definitely can be. That kind of serious deception could qualify as fraud. But you would need strong proof, of course.
That makes sense.
Okay.
Okay, so what about accident? Is that like if a key witness suddenly gets amnesia right before they're supposed to testify?
It could be something like that. Imagine a key witness gets in a serious car accident and they can't testify anymore. Or let's say a crucial document that supports your side of the case gets destroyed in a fire. These kind of situations, if they really skewed the fairness of the trial, could be grounds for relief under accident.
Yeah, that makes sense. But how does mistake fit into all of this? Is that like if the judge accidentally adds an extra 0 to the damages awarded?
Haha. Well, it could be a simple error like that, but mistake can also be about more fundamental blunders. Imagine a clerical error in the court records leads to a completely inaccurate judgment. That could be grounds for relief, especially if it had a major impact on the outcome of the case.
Got it. So we've covered fraud, accident, and mistake. Last but not least, we've got excusable negligence. This one seems particularly tricky.
Yeah, it's a tough one. Basically, you have to demonstrate that your previous lawyer was so incompetent, it's as if you had no representation at all. We're not talking about a few minor missteps, but negligence so severe that it basically robbed you of a fair shot in court.
Wow, that's a high bar to clear. And I'm guessing there's some strict deadlines involved here. You can't just stroll into court a year later and say, oops, I forgot to file this.
Absolutely. You have 60 days after you learn of the judgment and no more than 6 months from the date it was entered. Those are set in stone, no exceptions.
So you got to act fast. It's not like you can just sit on your rights and decide to challenge things years later. But I'm curious, how is this Rule 78 petition different from those motions for new trial or reconsideration I sometimes hear about?
That's a great question. Those motions happen before the judgment is final, while a Rule 38 petition is specifically for after the judgment is officially on the books.
Okay, so it's like a last-ditch effort to convince the same court to change its mind. And you mentioned something called an affidavit of merit earlier. What role does that play in all this?
Think of the affidavit of merit as your legal SOS message. It's a sworn statement that lays out exactly why you deserve relief under Rule 38. It's where you provide detailed evidence to back up your claims of fraud, accident, mistake, or excusable negligence. Basically, it's saying, hey, judge, here's why this judgment needs a second look.
So it's your chance to present all the evidence and arguments you think the court missed the first time around. But what happens if, even with your best affidavit of merit performance, the court still denies your Rule 38 petition? Are there any other options left on the table?
Well, that's where Rule 47 comes into play, Annulment of Judgment. Now we're moving into a whole different league. Instead of going back to the same court, you're filing a separate lawsuit in a higher court. You're essentially saying the original judgment is so flawed it needs to be wiped off the books entirely.
Whoa, that sounds serious. Like taking your case to the Supreme Court of legal remedies. But what kind of situations would justify something as drastic as annulment?
Annulment relies on two main grounds. First, extrinsic fraud, which is even more serious than the plain old fraud we talked about under Rule 38. This is about actions that tainted the entire legal process, like imagine someone tampering with witnesses or even bribing the judge, things that prevented a fair trial from even happening.
So it's not just about issues within the case itself, but about external factors that corrupted the whole system.
Exactly. And the second ground for annulment is lack of jurisdiction. This basically means the original court had no business deciding this case. Maybe it was the wrong type of court for that dispute, or they never really had authority over you to begin with.
Oh, so it's like saying, hey, that court's judgment doesn't mean anything because they shouldn't have been making decisions about this in the first place.
That's it. And just to give you an idea of how high the stakes can get with annulment, there's a fascinating 2021 case, Thomas versus Trono and Republic. It involved a child's inheritance hanging in the balance because of a questionable annulment.
Wow, that's intense.
Yeah.
But I'm guessing annulment isn't something you can just throw around lightly, right?
You're absolutely right. It's a very limited remedy, reserved for final judgments issued by regional trial courts, not just any old court order. Plus, there are strict time limits. You've got 4 years to file for annulment based on fraud. But if you're arguing lack of jurisdiction, latches can really hurt your chances, and that basically means unreasonable delay.
Okay, so annulment is like the legal equivalent of a nuclear option. Incredibly powerful, but only for extreme situations. But what if neither Rule 38 nor Rule 47 is an option? Is there any recourse left for someone dealing with a final judgment they believe is deeply flawed?
Well, there is one more option, but it's kind of a long shot. Collateral attack. You're not directly trying to overturn the judgment with this one, but instead you're challenging its validity in a completely different case.
So it's like saying, this judgment is so messed up that you can't even use it against me in this other legal matter.
Exactly. But here's the catch. It only works if the judgment is so obviously flawed, just by looking at it, that it's basically legally void. Think of it this way. A court that usually handles, say, traffic violations, suddenly issues a ruling on a complex patent dispute. It's so outside their authority that the judgment is basically meaningless.
So you're basically arguing that the judgment is so fundamentally wrong, it doesn't even count.
Exactly. And that brings us to a key distinction. Direct attack versus collateral attack. Direct attacks, like Rule 38 and Rule 47, are aimed at overturning the judgment head-on. Collateral attacks are more like a sidestep, saying the judgment is so bad, it's not even worth acknowledging.
Okay, that clarifies things. So we've got these three main paths to potentially challenge a final judgment: Rule 38, Rule 47, and this collateral attack. But as we've seen, each one comes with its own unique set of challenges and limitations.
Exactly. And while these remedies exist, it's important to remember that the legal system really favors the finality of judgments. These options are exceptions to the rule, designed for very specific circumstances.
Okay, so we've got this legal escape room, right? And we've found a few tools: Rule 38, Rule 47, and then there's this collateral attack thing, which kind of seems like a last resort hidden passage.
And keep in mind, just because you find the right tool doesn't mean you're going to escape. These judgments, they're tough nuts to crack.
So let's talk more about this collateral attack then. It's interesting how it's not about overturning the original judgment directly, but more like saying, hey, this judgment's so messed up you can't even use it against me in this other case over here.
It's a powerful defense strategy, but the key is that the original judgment has to be what we call void on its face. Legal jargon, I know, but it essentially means the judgment is so fundamentally flawed, it's like it never happened.
Okay, I need a little help visualizing that.
Yeah.
What kind of errors would make a judgment void on its face? Give me an example, a real-world scenario.
Okay, so imagine a scenario where a small claims court, which usually only handles, disputes under a certain amount of money, suddenly decides to rule on a super complicated constitutional issue. Or let's say a court issues a judgment against someone who was never even properly notified about the lawsuit.
So we're not talking about disagreeing with the judge's understanding of the law or how they saw the facts of the case. It's got to be a much bigger issue, something that undermines the court's power to even make a decision.
Exactly. The defects have to be super obvious, not something that requires a deep dive into complicated legal arguments to even figure out.
That sounds like a pretty high bar to clear, especially since we talked earlier about how much courts value the finality of judgments. They're not going to want to reopen cases lightly.
Right. They want things settled to give closure and stability. So trying to argue that a judgment is void on its face is a very difficult thing to do.
So you need a slam dunk case, a situation where it's totally undeniable that the court really overstepped its boundaries.
Absolutely. And even if a collateral attack works, succeeds in one specific case, it doesn't mean the original judgment just disappears altogether. It just means that particular judgment can't be used against you in that case. You know what I mean?
Oh, I see. So it's more like a shield than a sword. It protects you from the effects of a bad judgment in a specific situation, but doesn't erase the original judgment entirely.
Perfect analogy, and this is a good example of why getting expert legal advice is so important. A lawyer can really analyze your specific situation and determine if a collateral attack is even possible, and then, guide you through the steps.
Right, because trying to navigate these legal waters without a lawyer, it's like sailing without a map or a compass.
Couldn't have said it better myself. So we've got Rule 38, where you go back to the same court, Rule 47, where you appeal to a higher court, and then this collateral attack, which is kind of like a side maneuver in a completely different game.
And with all three, the clock is ticking. These aren't things you can just sit on forever.
You got it. Time is of the essence. Those deadlines are tight, and there are no extensions.
Okay, so let's bring this back to our listeners for a minute. We've thrown a lot of legal terms at them today. What are the big key takeaways they should walk away with?
All right, so first and foremost, even when a judge says case closed, it might not be the absolute end of the story. There are ways to challenge a final judgment, but they're not easy. Second, understanding those specific deadlines is crucial. You can't afford to wait around. And finally, don't even think about going it alone on this. Get yourself a lawyer, some expert legal advice if you're even considering any of these remedies. Trying to navigate this legal maze without a lawyer is, well, let's just say it's not a good idea.
Solid advice. But before we move on, I want to talk about something that often gets missed in these legal discussions. The human side of things. I mean, these aren't just abstract concepts, right? Judgments affect real people's lives in very real ways.
Oh, that's so true. I mean, imagine the pressure of having a judgment hanging over your head, affecting your finances, your relationships, even your reputation.
And the stress, the uncertainty alone, that can be overwhelming.
Right.
And then there's the emotional toll of actually fighting back,
Yeah.
having to relive all those difficult experiences, gathering evidence just to prove your case.
Absolutely. And don't forget the financial burden, legal fees, court costs, expert witnesses if you need them. All of that adds up really fast. So yeah, pursuing these remedies, it takes more than just legal knowledge. You need incredible resilience and strength.
But I imagine that in that struggle, there's also the potential for real growth and empowerment, right? I mean, it takes courage to stand up and say, no, this judgment is wrong, and I'm going to fight for what I believe is right.
It's about taking control in a situation where you might feel powerless, saying, I have a right to be heard. And even if things don't go your way in the end, the act of fighting back can be transformative.
I get what you're saying. It's like that saying, it's not whether you win or lose, it's how you play the game. Sometimes the fight itself is a victory.
Exactly. It can make you stronger, more resilient, and it gives you this deeper understanding of the legal system and your own inner strength.
That's a great point. Okay, so before we wrap up this part of the discussion, I want to go back to that concept of latches that you mentioned earlier. It's not a term most people are familiar with, but it can have a huge impact on these post-judgment remedies.
Right. Latches is all about unreasonable delay. It basically means that if you sit on your rights for too long, even though you know there might be a problem with the judgment, a court could decide not to help you.
So it's not just about meeting those strict deadlines, but about acting as soon as you realize there might be an issue.
Exactly. So let's say you knew about a potential lack of jurisdiction for years, but you didn't challenge it. The court might say, look, you had all this time, you can't wait around and then suddenly decide to do something when it's convenient for you.
It makes sense. The legal system depends on a certain level of efficiency and finality. You can't be going back and revisiting judgments from years ago just because someone wasn't paying attention.
Exactly. That's why having a good lawyer is so important. They're like an early warning system. They can help you spot those potential issues early on and advise you on the best way to move forward.
Right, because sometimes, even if you have a valid claim, waiting too long could hurt your chances. It's like ignoring a small crack in your foundation until the whole house starts to fall apart.
Now that's a powerful image, and it highlights how important it is to take action quickly. The longer you wait, the harder it is to fix the problem.
So today we've talked about The tools, the challenges, the deadlines, and even the ethical dilemmas that come with these post-judgment remedies. It's been quite a journey.
It really has. And I think our listeners now understand that even though a judgment might seem final, there are potential ways to challenge it. But those paths are tricky, and you need to proceed with caution.
And just like in that escape room, you don't want to try to do it alone.
Absolutely not. Having a lawyer is crucial. They're not just your guide, they're your advocate, your strategist, and they can give you emotional support through what can be a very stressful process.
So well said. To everyone listening out there, if you're dealing with a judgment that doesn't feel right, don't lose hope. There might be options you haven't even thought about. But remember, don't wait around. Find a good lawyer. And above all, keep your eye on the prize, a fair and just outcome.
It's been great unpacking all of this with you. And to our listeners, we hope this conversation has given you the knowledge and confidence to navigate these tricky post-judgment waters.
We've really been exploring this legal escape room, haven't we? Uncovering all these tools like Rule 38, Rule 47, even that kind of hidden passage of a collateral attack.
Yeah, and we've seen that even with the right tools, it's a challenge, right? Plus, we can't forget about the ethics involved. It's not about just gaming the system, it's about finding real justice.
That's a great point. It's like you wouldn't use a fire escape just because you don't feel like taking the stairs, right? There needs to be an actual fire, something you're trying to get away from.
Perfect analogy. And just like in a real fire, if you panic and just run in blindly, things can get even worse. That's where having a guide, someone who knows the way out, is so important, and that's where a lawyer comes in.
Right. It's not just about memorizing the steps. It's about the strategy, the timing, and knowing where the potential pitfalls are. And speaking of pitfalls, I can't stop thinking about that whole Lanches concept you mentioned. It's like there's a trap door that can open up beneath you when you least expect it.
Oh, it definitely can. Lanches is basically a fancy way of saying you snooze, you lose in legal terms. If you knew or should have known about a problem with a judgment, but you waited too long to do anything about it, the court might not be willing to help you.
So it's not just about those strict deadlines for filing motions and things like that, but about being proactive right from the beginning. The second you think something might be wrong, that's when you need to get legal advice.
Yeah. Exactly. Time is not on your side in these situations. Let's say you find out about a potential issue with jurisdiction years after the judgment. The court might say, well, you had plenty of time to raise this before. Why are you coming to us now?
Right, makes sense. The legal system has to be efficient. There has to be a sense of finality. They can't be constantly revisiting old judgments just because someone wasn't paying attention.
Exactly. And that's where a good lawyer can be so valuable, like an early warning system. Yeah. They can identify those potential red flags right away and tell you what your best options are.
Yeah, sometimes even if you have a legitimate claim, waiting too long can really weaken your position. It's like ignoring a small crack in your house's foundation and then being surprised when the whole thing starts to crumble.
That's a great way to put it. It shows how important it is to take action, and the sooner the better. The longer you wait, the harder it is to fix.
So we've covered a lot of ground. The tools, the challenges, the deadlines, even the ethical questions that come with these post-judgment remedies. This has been a deep dive if I've ever seen one.
It really has, and I think anyone listening now understands that even though a judgment may seem like the end of the road, there might be ways to challenge it. But those paths are tricky. You need to be careful.
And just like in an escape room, you don't want to go in there alone.
Definitely not. Having a lawyer by your side is absolutely crucial. They're not just a guide. They're an advocate, a strategist, someone who can support you through what can be a really tough process.
Couldn't have said it better myself. So, to our listeners out there, if you're dealing with a judgment that doesn't sit right with you, don't give up hope. There might be options you haven't even considered yet. But remember, time matters. Act fast, find yourself a good lawyer, and most importantly, don't lose sight of that goal, a just and fair resolution.
Well said. It's been great exploring all this with you today.